Docket, State of Kansas versus David Allen Kershaw, 109548. Counsel?
Good morning. May it please the court, the state appears by Assistant District Attorney Jody Lipton. Your Honor, I request 2 minutes for rebuttal.
2 minutes is granted. Thank you.
We're here today on the state's petition for review for one issue in Mr. Kershaw's case. He was convicted of 4 counts of aggravated assault on a law enforcement officer, and the jury was instructed that voluntary intoxication was not a defense to that crime, as well as domestic battery, which he ultimately wasn't convicted for, the domestic battery. There was no objection by Mr. Kershaw's counsel, and he was ultimately convicted and raised 3 issues in his direct appeal. That aggravated assault on a law enforcement officer was actually a specific intent crime, so he should have been given the voluntary intoxication instruction. That he was denied his right to present his defense, and the 3rd issue was that the district court erred when it affirmatively instructed the jury that voluntary intoxication was not a defense to aggravated assault on a law enforcement officer. The state has not petitioned this court to review the first 2 issues. We agree with the Court of Appeals in their reasoning on the first 2 issues, but we disagree with the ultimate determination that the instruction that was given was clear error. I do want to note that at the Court of Appeals level, I filed a 609B letter saying that that instruction did not come from the PIC. That is incorrect, and I would like to go back and say that it is from the PIC, so if I could just make that clarification. I don't know where that confusion came from on my part, but it did come from the PIC, just to clear that up, because I believe the Court of Appeals was asking where that instruction came from. In the Court of Appeals opinion, they talk about how aggravated assault on a law enforcement officer is a general intent crime. This court knows that voluntary intoxication is not a defense that can be used for general intent crimes. They're only for specific intent crimes. The instruction that was given to the jury was a correct statement of law, and the Court of Appeals agreed with that. And the jury was also given several other instructions, which we don't believe the Court of Appeals read all of the instructions in total and as a whole, and maybe just picked out this instruction when it held it was error, the voluntary intoxication instruction. The jury was instructed right after, I think it was instruction 8, talking about voluntary intoxication was not a defense. The next instruction was the knowingly instruction, and the jury was told that the defendant acts knowingly when the defendant is aware of his conduct, that his conduct was reasonably certain to cause the result complained about by the state. And then in the next 4 instructions, there was the elements of aggravated assault on a law enforcement officer, which the first element is that the defendant knowingly placed each sheriff's deputy in reasonable apprehension of immediate bodily harm. And instruction number 6 was the state's burden of proof instruction, which came before the instruction that voluntary intoxication was not a defense. So reading those instructions as a whole, we believe that all of those are correct statements of law, and that the voluntary affirmative instruction that voluntary intoxication is not a defense did not negate the state's burden to prove that the defendant acted knowingly.
And included in all that is that the jury had to find that Mr. Kershaw intended the result.
Well,
you read one of the definitions that he knowingly caused the result.
He was reasonably certain to cause the result complained about by the state. And I think that's one of the 3, I was looking at that yesterday, in the knowingly instruction, there's, I think, 2 or 3 prongs that you can choose from, and there was some discussion about that in the jury instructions conference about which one of these should we put in, and I think that was the bullet point from the PIC that they chose to define knowingly. Also, I think it's interesting here that I don't think the jury could be more clear to the jury that they had to find that it was knowingly. Both the prosecutor and the defense counsel in their closing arguments repeatedly pointed out that he had to know what he was doing, and he had to commit the crime knowingly. The state obviously argued that he did, and the defense made a strong argument that he was not aware, and pointed out the defendant's testimony that he didn't know what he was doing. So I think both the prosecutor and defense counsel here hit the nail on the head when they told the jury that they couldn't consider voluntary intoxication, but they still had to find that he committed the crimes knowingly. So I guess our confusion just comes from the Court of Appeals finding that the instruction negated the element when both parties clearly explained to the jury that they had to find, not an additional, but they had to find that he committed the crime knowingly. Again, I think that's the way that the prosecutor started out her closing argument was, the state has the burden of proof here. We have to show he did it knowingly. Look at his actions. That's how we can show that he did it knowingly. And again, there was evidence here that they could have found that he did not do it knowingly because he got up there and testified that he didn't know what he was doing. And they acquitted him of the domestic battery, so obviously the jury did do a weighing of the evidence here. The only other thing that I cited in my petition for review were a couple of cases, two from the Court of Appeals that were unpublished and one from this court that I think supports my argument. And in those cases, voluntary intoxication, the instruction that it is not a defense, the affirmative instruction was given. In all of those cases, there were general intent crimes, aggravated batteries, or an aggravated robbery. And this court and those other panels of the Court of Appeals held that that was not error to give because it was a correct statement of law and did not held that it negated the state's burden of proof.
What I'm having problems with is one of the arguments the prosecutor made on closing was that, the statement was made, the state also has to prove that he did so knowingly, but then goes on to say, hey, it's not a free pass if you're drunk, and but at one point, the prosecutor says, being drunk is a powerful explanation for one's action, but it's not an excuse. And I agree that we have said that it's not an affirmative defense to be voluntarily intoxicated, but it seems to me after Hobbs we've indicated that knowingly means to have reasonably anticipated the result, and that's sort of in the middle to me, whether it's consideration as to whether you prove the element versus being a defense that negates the whole charge. It's splitting a hair in my estimation, and I sort of read at first blush the Court of Appeals says voluntary intoxication is not a defense, but you can't tell the jury voluntary intoxication is not a defense. At first seems a little ridiculous, but then when you think about it, what they're actually saying is that it can be a consideration because one of the elements is that the defendant had to knowingly or reasonably believe that this result would obtain. And so how do we give credence to both sides of that?
Well, I guess my response to that would be, does it make the jury instruction that was given here an accurate statement of law? Because they held that it was a correct statement of law. Now, whether it should be maybe further explained, or I think now they give a further explanation, or there is a PIC instruction that talks about, well, maybe that's for the specific intent crime and using voluntary intoxication. I mean, maybe if there needed to be more clarifying language in the future on exactly what it can be used for, I don't think that it makes it an incorrect statement of law in this case to where it negated our burden of proof and where it made it unclear for the jury that he didn't have to prove that he knowingly committed the crime, if that answers your question.
Well, can intoxication go to whether the actions of the defendant was knowing? And my problem is I think it can. I mean, that's part of the mental state that has to be considered when you have to commit a crime knowingly as
Yes.
opposed to intentionally. But
Yes.
knowingly, and intoxication it requires a certain mental state.
Yes.
And intoxication can impact that. And my problem here, when you say voluntary intoxication is not a defense, it seems to me that that blanket instruction precludes consideration of what I just said, that intoxication can impact the knowing aspect of what it takes to commit this crime. And that's where I'm having trouble here, is trying to figure out where that all fits. Because I understand what the state of the law is
Right.
with specific intent, but when you have a knowing aspect that is required, and an evidence here of consumption of a considerable amount of alcohol coupled with the prescription drugs that were going on, and then Dr. Logan's proffered testimony and his testimony,
Right.
why can't the jury consider that? And how can the jury consider that when you have a voluntary intoxication is not a defense?
When you're
It's
telling
kinda-
them not to.
Yeah.
Again, that goes back to maybe it needed to be further. There needed to be additional language telling them that they could consider it, but it doesn't. It's not a complete defense. That if you find he was drunk, then
Right.
he's innocent.
I think complete
Um,
defenses maybe would help quite a bit.
So maybe further
In addition-
narrowing
Yeah.
when it could be used. But still, I guess I just don't see it as being clear error since it's not a misstatement of the law.
Right,
Well,
I understand.
And they're I think in closing they're trying to narrow it and explain it.
It's not a complete statement of the law as we've interpreted it. I think we've been a little bright line on voluntary intoxication given the statute. The statute doesn't say specific intent. It says particular intent or other state of mind. And we have a state of mind in this particular crime that is more than a general intent to discharge a firearm,
Right.
right?
Yes.
And then it goes on to say it may be taken into consideration in determining such intent or state of mind. So our general specific bright line has really not given effect to the language of the statute, has it?
No. And like I said, I think there's another PIC instruction, and that language may be in the PIC instruction for specific intent. But maybe the specific general, those terms, maybe we need to broaden that. And
Did you
include
look at
it.
our recent case in Hobbs where we had, it was an aggravated battery and we dealt with the new definitions of know and knowingly and said it's not as clear cut as we've
I did not review that case
Okay.
prior to today, but I agree that it's not, general and specific they're confusing still.
And they
It's
may-
not just,
Even to the extent they were understandable before the
Right.
amendment, now they're definitely confusing.
Yes.
Because the legislatures used them somewhat differently from the way they were understood prior.
yes. And I think that were obviously all of the issues in the appeal in this case was, despite the fact that it's called a general intent crime, is it really, are we interpreting it as a specific intent crime? But I think, reason for filing the petition is it clear error? Do we get there even though he agreed that it should be given? I mean,
And
does it rise to that
the
level?
date of this shooting again was when?
Never mind, I got it.
2012.
2012, okay.
Okay.
Sorry, Your Honor.
No, that's all right. I just wanted to make sure.
I think it
The
was,
right
yeah.
time.
And in the jury instructions, they talk about this is all new and they're
Right.
trying to
Figure it out.
wrestle with what they need to put in there.
Yeah,
So-
I want to take a look at Hobbs. Okay.
And I think that concludes my comments, if there are no further questions.
I just have a query here.
Yes,
Does the legislature, general versus specific is a legal question. Does the legislature get to define that? I mean, they define crimes. Can they define what's general intent and what's specific? Because we have the statute here that says if it's knowing, it's a general intent. Yeah.
I think yes.
Any further questions? Okay, thank you.
Thank you.
May it please the court, Sarah Ellen Johnson of the Capitol Appellate Defender Office on behalf of David Kershaw, who is present in the courtroom. A couple of points. I guess I want to start with disputing the idea that this is a correct statement of the law. If you look at the intoxication statute, now it's 215205, the old number is 3208. It doesn't say voluntary intoxication is not a defense. It says it doesn't make one's actions less criminal, and then it goes on to say that the fact of intoxication may be taken into consideration in determining the defendant's intent or state of mind. And that's what we have here, is that we have a state of mind at play, and so to me it's not a correct statement of the law to blanketly tell the jury voluntary intoxication is not a defense, end of discussion. A more correct instruction would be to say it's not a defense to criminal actions perhaps, but it can be taken into consideration when considering a particular crime and the particular elements of a crime, and that's what's not here. So the way that this instruction is written right now, I don't agree is a correct statement of the law.
How should it be written? And then what is a correct statement of the law?
I've never been involved in writing jury instructions before,
but you're saying it's not. But
I would suggest that the jury instruction should follow the language of the statute, and the statute itself doesn't say voluntary intoxication is not a defense, which I think, getting to something that Justice Johnson suggested, I think defense is sort of a term of art that we as lawyers know. What we're talking about, affirmative defenses that negate maybe the entire crime or legal culpability.
Yeah, complete defense may not help you with the
right. We understand what we mean when we say that, but we're now telling that to jurors without any of the backstory filled in. We're simply telling them it's not a defense. And I don't know how a lay juror, without knowing how we as lawyers intend that word to be read, are going to make any heads or tails of, well, we're supposed to find that he did this knowingly, but voluntary intoxication is not a defense. I think we're telling jurors then you can't consider that. And that's the only way that you're going to get to this wasn't knowingly done, that he was in this state based on the medications he was on and the alcohol that he had consumed. And when you tell jurors you can't consider that, I don't know how a lay juror is supposed to really consider properly the facts in the law that apply to this case. So I think a jury instruction that tells them, as the statute does, it's not a defense overall to criminal activity. It's not the free pass to commit crimes, but when it comes to this particular crime, you may consider the fact of intoxication as it relates to in this case, it would be the mental state involved. I think that would be the correct instruction. I think telling the jury voluntary intoxication is not a defense is definitely not the correct statement, and I think that shuts down a real consideration in the jury room of the issue in this case, which was, did he know what he was doing? And there's plenty of evidence.
In that regard, actually the state helped out the defense, I think, in its closing argument. Because one of the statements made was, and just because you are drunk doesn't mean you don't know what you are doing. And that, to me, that's what we're involved with here. Did he know enough what he was doing to be reasonably certain to cause the result that obtained? So when we're talking about clearly erroneous, isn't this part of the calculus that the state argued it the way it should be?
Well, I think the state argued it also a little bit the way it shouldn't be, in arguing it's not a free pass. And in getting into
And it's not a free pass. It's not a complete affirmative defense. You prove voluntary intoxication, you win. You have to show that as a consideration of the state of mind the state has to prove, you get to consider that, but it's not a free pass.
Absolutely, but that's not what the jury was instructed. The jury was instructed voluntary intoxication is not a defense. And then they're given this argument by the prosecutor reinforcing the judge has just instructed you that voluntary intoxication is not a defense. The defendant told you nobody forced him to drink. I drank by myself. I chose to consume that alcohol. It's not a free pass, is what the state says. I think that argument is sort of consolidating this idea to the jury that just because you're drunk doesn't mean that you're not guilty of the crime, and you jurors don't get to consider that.
Is there any difference between those two terms, is not a defense versus you shall not consider? The statute does use the language take into consideration.
Right.
Is that any different from is not a defense?
I do think it is, especially.
What's the difference?
The difference is that we are telling jurors who don't know the law, who don't know the full breadth of the criminal statutes, and to say is not a defense, I think is a term of art to lawyers that does
But
not.
I'm sorry to interrupt, but
No, that's fine.
if you can't take a fact into consideration, then it's not a defense. I'm having a hard time seeing the difference between those two.
Well, but the difference is that the jurors under the statute could take the fact of intoxication into consideration, but they're not told that. They're simply told it's not a defense.
Right, so your argument is that in 21-5205, that phrase "other state of mind" includes a
Knowingly.
knowing state of mind. What's your support for that position?
The plain language of the statute.
So point me to where in the statute it says that phrase "other state of mind" includes a knowing state of mind.
Well, I would look to. I don't have a authority for that. I guess it's logical to me, though, that if you have to knowingly do something,
Right.
that's a state of mind.
I understand
That's
your
not-
sort of common sense argument, but I was just curious if there's some other statute or some other provision of this statute that you're relying on to support the conclusion that the phrase "other state of mind" includes knowingly.
I'm simply relying on the plain language of that statute, and that the common sense definition of knowingly would be that that's a state of mind, that you're not.
Even though elsewhere the legislature has said that state of mind is only a general intent state of mind.
But it's still a state of mind,
Okay.
is the ultimate point. Whether it's getting caught up in this language of general intent crimes versus specific intent crimes, there's still a state of mind at play in this statute, and we have told the jurors voluntary intoxication is not a defense. And that is the consideration that they should be focusing on when they're deciding whether Mr. Kershaw knowingly committed these acts.
What cuts against you a little bit, I believe, is that apparently we adopted the voluntary intoxication statute from Minnesota, and Minnesota in the Fleck case interpreted particular intent to be specific intent crime. So I think that's how they've applied that. In other words, the same language in Minnesota has been applied to do what we've done, the specific intent, general intent.
Does the Minnesota statute also include that or state of mind language?
I can't answer that.
Is that would be the first thing I would want to look at is, because again, that's what we're relying on is the idea that you have to knowingly do this. And the state never disputed this, still isn't disputing that there's this knowingly point to it, and that is the entire crux of the defense, is that he really didn't know what he was doing at that point. He had to be told later. He had previously, while on this particular medication, Chantix, been in these sort of states where he was sleepwalking, where he would sit on the edge of the bed and type on a typewriter that wasn't there. And his wife, who witnessed all of these, would say she'd look into his eyes and it was like there was nothing there. So that's why this is so critical, is to consider, did he knowingly do any of these things if he really wasn't even mentally present in his body at the time that this was happening, as he had not been in some of these previous incidents? That is what the jury needs to consider. It's not a complete defense to criminal actions, but it is relevant and should be taken into consideration by the jurors when we're talking about this particular crime that he was charged with, this aggravated assault. And that is our position.
But it's aggravated assault on a law enforcement officer, right?
Yes.
And we know that he was talking to a negotiator. He knew the police were out there. 45 minutes went by. He then counts, points, and shoots. And I'm sort of getting back to where the state is clinging to clear error. And that's
Right.
what I'm trying to focus on here. You know, I'm having trouble being firmly convinced that if this instruction had not been given, that there would be a different outcome.
I would point your honor to a couple of facts. The first is Mrs. Kershaw's testimony about previous sleepwalking incidents, almost as she described them, under the influence of this medication, where he was talking, doing things, but clearly not actually responsive. And it's reasonable to think that that was the sort of state that he was in. There was also a previous accidental discharge on his part of that gun just soon before this incident.
Right, I mean,
That
he
same
went out
night.
and found the ammunition, he got his clip, and he put the clip in the gun. I mean, there's a lot that that sort of works against, to me, the notion that the verdict would have been different.
To me, that evidence is compelling to suggest that this is something other than a knowing crime, that this is perhaps a reckless sort of incident, but not a knowingly placing people in fear based on all of the sorts of incidents that had happened before, based on the sheer quantity of alcohol that he had consumed and the various prescriptions that he had taken that night.
But again, the facts of this particular case cut against you a little bit. Ordinarily, we would not have Dr. Logan testifying as to the general effects of all of these medications, and we got it. Defense got in all the evidence about the typing, doing air typing and being trance-like, and all of that stuff. So that was all presented to the jury.
Correct.
And they were also given the instructions that set forth the state of mind they had to find.
Correct.
And so it's whether we're firmly convinced that this one instruction in isolation would have pushed them to find guilt.
And
Even-
again, I would come back to, this is the key instruction. You're telling the jurors voluntary intoxication is not a defense. To a lay person, I think that's the same as telling them you really can't consider that. There are so many layers of law that go into what we as the lawyers and the judges in the courtroom understand in that statement that simply aren't there for the jurors. I think that to a lay person is simply a shutting down consideration of voluntary intoxication.
I don't recall, did we have any jury questions in this case?
I don't believe so.
Yeah, I didn't recall any either. Okay.
I would simply ask that this court affirm the Court of Appeals' decision on this issue.
Any more questions? Thank you, counsel.
Thank you.
May it please the court, I don't know if I want to open up this or make this comment, but I'm going to throw it out there. If the jury hadn't been instructed that voluntary intoxication wasn't a defense, I think it would be a reasonable conclusion to think that they would have acquitted him on these charges because of all the evidence that was presented. And I don't think that would be a correct conclusion that they would have come to because of all the evidence that got in with the doctor. I think they could have jumped to the conclusion that he was intoxicated, and they could have not convicted him on all of the crimes, and that would have been an incorrect conclusion. So even if this was a broad statement or in maybe not as narrowly tailored instruction, I think it's important that it was given to the jury so they would know that it couldn't be a complete defense.
So I just want to clarify where that leaves us, and this is probably why you didn't want to
I
get
know,
into it.
and because
But it's, my understanding of defense argument is that it just should not have been given. And that the fact it was given changed the outcome, right? Or
Yes.
controlled the outcome.
yes,
And you're basically conceding that the fact that it was given controlled the outcome. But you're saying that would have been an incorrect result? And you're basing that on what? I mean, how do we know what the result?
We
Whether
don't.
it's correct or not, I mean, the jury is the one that tells us what they think. Okay, so that
right.
clarifies that for me.
And I don't know, but yeah, probably.
But it really sounds like both of you have argued today for a modified instruction, possibly. I
yes.
mean, your opponent for an instruction that mimics the words of the statute. And you said, I think when you were up before, at least say something like a complete defense or something, you think a modification would be in order. Okay, I
Correct.
just wanted to make sure had understood your position. Okay.
Yes, and I don't think that I'm arguing that it's not. I'm still arguing that it's a correct statement of law. Maybe an incomplete statement of law would be the way that this court is going to go.
What is your opinion, if you have one, as to what that phrase "other state of mind" means in 21-5205?
I thought that was referring to specific intent, because you need an act with a specific state of mind for.
Does
specific
that
intent.
phrase "other state of mind" encompass knowing?
Knowingly, I would argue that it doesn't.
Okay. Do you have an opinion as to what what is it other than other state
Yeah.
of mind than what? I'm just struggling
Because
over
there
that
is-
phrase to figure out what that means.
And there is no other states of. I mean, there's intentionally, there's knowingly, there's recklessly. So other state of mind, I guess, would have to go to the other two states of mind that were given.
Why is it not included? Why is knowingly an exception to other state of mind? What's your support for that?
I don't
think
have
that
any.
was my
I don't-
colleague's question to your opponent, and now I'm going to ask it of you as well.
I don't have any support for that.
Okay.
I don't know if I can explain what other state of mind, what that refers to. I'm just thinking in the context of, in order to get a voluntary intoxication instruction, it only applies. I mean, you would only get that instruction for a specific intent crime.
Why is the amended statute on mens rea not support for one or the other of you? I mean, it's right there talking about what the states of mind are. The definitional statute intentionally means this, knowingly means this. I mean,
Right.
why is that not support for the fact that all of those are states of mind under
And that it could
the
have,
involuntary intoxication statute?
I guess it is.
Which is a question I really posed to both of you, but
Right.
okay, thank you.
Could I clarify?
Yes, sir.
From your petition for review, you made the statement that the evidence presented could have led the jury to believe that Kershaw did not knowingly commit the crimes due solely to his intoxication. And what you're saying today, I want to clarify, you're conceding that the evidence as presented could have led a jury to find that the intent element, not to find the intent element required for the ag assault. Or am I reading your words
I think
incorrectly?
I think that's correct. I
You're
think
saying they would not have. I mean, the clearly erroneous is firmly convinced they would, but you're saying there was sufficient
They could have.
evidence from which, or sufficient evidence of intoxication from which the jury could have negated the requisite state of mind.
yes.
Okay.
And yeah, based on the doctor's testimony and his, I think that's correct.
Any more questions? Thank you, counsel.
Thanks, Judge.
Thank you both for your arguments this morning. Court will take this matter under advisement. That concludes